So everyone knows this presentation is being recorded, and we will make the presentation available through the website for later review so that others can partake and enjoy and learn from the information we present today. So it is October 12th, 2021, and this is our quarterly EAP seminar presented by the DC Chamber of Commerce to employers throughout the district area. And today we have a special introduction for the EAP seminar being presented by Stacy Burnett and Comcast. And Stacy has some information for employers and small businesses. And without further ado, Ms. Burnett.
Thank you, Ryan. Thank you and Angela for providing me the opportunity to speak to the Employer Advocacy Program participants today. So hopefully the information I share is something that is useful to all of you, and if not all of you, someone that you know, if it's not going to directly impact you. So during the pandemic, so many small businesses, and particularly those owned by people of color, have struggled to stay open and operational. And in response to that, Comcast developed what's called the RISE Investment Fund. And the purpose of the program is to provide financial support to small businesses owned by people of color. And we are offering $10,000 grants to small businesses owned by people of color. And there are only 3 eligibility requirements. Number 1, you have to have been in business for at least 3 years. Number 2, you have to have 25 or fewer employees. So if you're just a solo act, that's perfect. If you have 10 folks, you have 24 folks, just not more than 25. And then you have to have a current DC business license. And so the deadline for the program to apply for the $10,000 grants, and there are 100 of them that we will be granting, the deadline is October 14th. That's 2 days from now. And you can access information about the program at comcastrise.com. That's comcastrise.com. And I think there's some information about the program on the Chamber's website and the link to comcastrise.com. So please apply. Your chances of winning are extremely high. And if you don't qualify, please share this information with someone who might qualify. Thank you again, Ryan and Angela, for this opportunity, and have a great day. I've been to these EAP program events in the past, and they're always so informative. So I'm sure there's a great schedule with information-packed things that you'll take away from the session today.
Thank you, Stacy. So, Angela, do you have any opening remarks you'd like to make?
No, I want to thank everybody for, for supporting us this morning, to the interim director, and to Larry. Thank you so much for your participation. We'll save, this is going to be recorded, so we'll keep it on the website for future information. So that link we can send, we'll send as well in our newsletter, so that we can share the information later. So thanks again. And Stacy, to you, thank you. We've been promoting the program. Hopefully you've gotten a lot of, we promote, but we never know how many businesses take advantage of it. So hopefully we will get some feedback, but that's a great program. Thank you for your participation.
Thank you,
Back to you, Ryan.
Of course. So today we have a special presentation from the Office of Human Rights of Washington, D.C., or the District of Columbia. And with us today is Nin Kane and Larry Perez of the Office of Human Rights. So today's presentation will start with them. However, before we kick it off and kick it over to them, I would just like to talk briefly about what the Employer Advocacy Program is all about. The Employer Advocacy Program allows the DC Chamber of Commerce to provide legal counsel to employers in the district area when they are confronted with claims before for unemployment compensation before the Office of Administrative Hearings. Before the Office of Administrative Hearings, we step in and provide counsel to those employers in need. It is a free service, meaning we will step in, provide counsel free of charge to the employers. This enables the employers to have quality representation, understand the process, and be advocated for without any overbearing cost to them, as that seems to be a burden for many employers, having to deal with litigation, and being small businesses, that added expense can be troublesome. And it's important to have representation for the administration of any case, because knowledge of the system ultimately can dictate how your case will be resolved. And we have the expertise, as we practice before the Office of Administrative Hearings regularly and handle these types of cases regularly. Most situations that occur is where employers and an employee have a separation, and an employee seeks to gain unemployment benefits. Oftentimes, the employer disagrees with this employee seeking unemployment benefits because they either quit, they acted in a way that would exclude them because of misconduct, or another such issue that we've been seeing regularly is that there's some sort of fraud. And through the pandemic, that has been a big issue of people claiming unemployment benefits using other people's social security numbers. And oftentimes, and this is another circumstance, is that employees will seek unemployment from the wrong base period employer, meaning they would get unemployment benefits, but it's attributed to a previous employer. These cases are a little bit more rare, but having us step in and advocate on your behalf makes all the difference. And appearing before a judge and this tribunal, having experience matters. So today, and also in the EAP program, we provide these seminars quarterly. These seminars update employers on laws, regulations, and policy that affects them in their everyday business. And we hope that our seminars enable employers to be encouraged and be informed, and know that there are resources for them outside of what they may know is possible through their daily, actions and their business that swamp them regularly. So we want to gain awareness about the EAP program, and we want to gain awareness about the services that the DC Chamber of Commerce offers. So today we have the director, the current interim director for the Office of Human Rights, Nin Kind, here with us. And she was previously the general counsel for the Office of Human Rights, and her experience has given her the opportunity to step in as the director and guide the office in a positive direction from here. So we're going to have a bit of a discourse and a presentation concerning updates with the new landscape of the employer world in this new environment, work from home and other such issues. So Director Kind.
Thank you, Ryan, for that warm welcome. Good morning, everyone. Again, as Ryan introduced, my name is Nin Kind, and I'm from the DC Office of Human Rights. I'm so glad to be here along with my colleague, Larry, whom I will introduce a little bit later on when he talks about the new Tip-Waged Worker Fairness Act. So without further ado, I'll get started. I see that we're a fairly small group this morning, so I encourage you to be very interactive, ask questions, and I'll take them as they come along. So with that, I will share the screen and see if we can do this. Okay, you can see the screen a little bit, I imagine. Ryan, will you give me a nod if
Yes,
Thank you, nodding.
great. Let me put it into
that's better. That's better.
presentation mode so you can see it even better.
That's
All
great.
right. So this morning, I'm going to tell you a little bit about OHR if you've never heard of us. We, on behalf of residents, employees, and visitors to the district, try to eradicate discrimination through increased equal opportunity, and we protect civil rights through enforcement of the laws we have jurisdiction over. So today I'll be going over a few of these laws with a particular focus on those that might be of particular use to you, as Ryan mentioned, in this new landscape of workplace we're dealing with in the pandemic. All right, so how do we achieve our mission at the Office of Human Rights? We investigate, we mediate. If what we call probable cause is found, we conciliate. And if there is probable cause and conciliation fails, we also prosecute cases at a public hearing before the Commission on Human Rights. This last bit is probably a little bit not as well known, as this is a newer program we launched back in, I want to say 2018. All right, we also conduct, as you're living through today, some training and outreach throughout the year. All right, so what are some of the areas covered by our office? Can anyone tell us? I like for this to be, as I mentioned, as interactive as possible so that you can be as informed today. I have given you some clues with the icons, but what do you think are the areas of laws that we cover at the Office of Human Rights? Go ahead and put your answers in the chats, or if you don't mind, chime in, unmute yourself. Okay, I am seeing some stuff coming through. Let's see. Workplace. Thank you, Angela. That's right, employment. Anybody else? Yeah, employment. That's certainly the top big one that we cover. Housing is the other. Public accommodations. That might be of interest to some of you who might have businesses that provide services or sale of goods. Educational institutions. So we cover schools. We also cover government services. If you go to the DMV, that would be covered. All right. So what are some of these laws that I'm talking about? Uh-oh, technical difficulty. There we go. So hopefully you know the big one that we enforce, the DC Human Rights Act of 1977. Okay, I'm gonna give you a little update on that in a moment here. We also enforce the DC Family and Medical Leave Act, and I assume most of you are familiar with that one. DC Parental Leave Act. All right, we also enforce the DC Unemployed, excuse me, that's a typo. DC Unemployed Anti-Discrimination Act of 2013. As you might guess from the name of this law, this aims to protect non-discrimination against people who are unemployed. So if you recall, we had sort of a great recession in 2009 to 2010, where folks could not get a job because they were unemployed. And so the DC Council legislated this particular piece of law that says employers cannot discriminate against someone because they are unemployed at the time of the application. Otherwise, it would just be a never-ending loop. All right. We also have the DC Protecting Pregnant Workers Fairness Act. We have the DC Fair Criminal Record Screening Amendment Act. This prohibits employers from inquiring directly or indirectly about someone's criminal background history prior to a conditional offer of employment. That's very important latter phrase, prior to a conditional offer of employment. That one's fairly been on the books for a while now, since it was enacted in 2014. Some of the newer ones are as follows: employment protections for victims of domestic violence, sexual offense, and stalking, which we call DVSOS. This took effect in 2019. And what this does is prohibits discrimination against victims of domestic violence, sexual offense, or stalking. Further, what it does is that it requires employers to provide reasonable accommodation for these victims. All right, we also have some of the newer laws coming up here, the Universal Paid Leave Act. If you follow the DC Council's work, you'll know that in the last few years, there's been a lot of work that has gone into the creation and establishment of the Universal Paid Leave Act, which allows employees, private employees working for private employers, to get paid for certain types of leave. And because this has not been as well known and fairly new, I'm going to go over more details around this particular law as well. The next one is one of our newest, Tipped Wage Workers Fairness Amendment Act of 2018. All right. So hopefully, let me go back to the list for a second. Hopefully, you're familiar with the DC Human Rights Act, the DC FMLA, as I mentioned, the Unemployed Anti-Discrimination Act is fairly straightforward. Protecting Pregnant Workers Fairness Act, which prohibits discrimination against pregnant workers and also requires reasonable accommodation for pregnant workers. That again, because some of these have been on the books for a while, you all are familiar with it, but I am going to give you some updates on 1, 2, 8, and 9. If you're not familiar with these laws, however, I really encourage you to attend our Human Rights Liaison training at the Office of Human Rights. We try to offer those on a quarterly basis, but within the pandemic, I believe we've only been able to do perhaps biannual. But we are trying to get those back on the books, and that's a day-long program that will talk to you and explain to you about all the details of these laws that we enforce. Any questions so far? And Ryan and Larry, if you can help me, if there are questions in the chat that come through, if I don't see it, please let me know.
Have you seen the message from Rosa?
I have not.
The Language Access Act of 2004?
That's right. We also enforce the Language Access Act of 2004. That's correct. And so part of the, and I will say is the caveat is that this is a partial list relating to employment law, because I know that as employers, you're probably more highly concerned with that, but we also have a number of other laws that I haven't included here for time and brevity that you might not be as interested in. But if you visit our website at ohr.dc.gov, you will find a full list of our laws. But thank you, Rosa, for that addition. I appreciate it. Okay, so because we have what's called a work sharing agreement with the EEOC as well as HUD, we enforce some of these employment laws with respect to our work sharing agreement with the EEOC. Title VII of the so used to saying Human Rights Act, Title VII of the Civil Rights Act of 1964, which I call the mother of the civil rights, and then the Age Discrimination and Employment Act, the Americans with Disabilities Act, and the Genetic Information Non-Discrimination Act. I'm going to pause here for a second to make a distinction about ADEA. How old must an employee be to be covered by ADEA under this federal law? Anyone know? I hear crickets. Come on, we know. Take a wild guess.
But I don't want to get it wrong. That'd be embarrassing.
That's okay. We're all here to learn. Safe space.
No, I think it's any age.
So under the ADEA, under federal law, you have to be 40 or over, right? When I turned 40, I said, I am officially an older worker recognized by the ADEA. You have to be 40 or older. In DC, however, under the Human Rights Act, the age protected trade is 18. That means you only have to be 18 or over to be covered by the DC Human Rights Act. What does that mean? The federal law tends to protect what they call older workers, but DC also covers younger workers. In other words, you can't discriminate against someone because they happen to be younger than you anticipate a person to be in a particular given job. Okay, so that's a big distinction that folks don't often know about. So I wanted to state that for you here. Any questions so far before I move on to the next slide? Okay. All right, another pop quiz for you here. How many protected traits do you think there are in the district under the Human Rights Act? I can tell you under the federal law, that Title VII that I mentioned, it's about 4 or 5, right? Race, national origin, religion, sex. What else am I forgetting, Ryan?
Color your skin, yes.
5. Guess how many there are in DC?
I think there's 7.
Way more. There are 21 protected traits in DC. Now, remember, the Human Rights Act covers other areas beyond employment, which is why it's 21. For employment, there are 18, which is still much more broader than the federal Title VII. Okay, so here are all of the different protected traits in DC, all 21 of them I've put up on the screen for you. The orange ones are those that don't apply to employment, okay? And then the blue ones, religion and disability. We're going to talk about that a little bit because I know that's a hot topic today, again, as Ryan described our landscape for us this morning in this new era of workplace environment with the pandemic, with the religious accommodation, disability accommodations. We're going to talk about that a little bit. I can spend an entire day talking about each of these protected traits, but there are 18. I'll just run through a couple of these that are maybe different and maybe that folks are not aware of because it's not covered under federal, right? You're probably familiar with race, color, sex, national origin, religion, disability, age. I'm gonna have to minimize my screen here so I can see the whole thing. Sexual orientation, gender identity and expression, genetic information, marital status. That's something different, right? You might not have heard of that. That has to do with someone's status as married, divorced, unmarried, that sort of thing. Matriculation, that has to do with someone being enrolled in educational institution, not the person's pedigree. So we're not talking about if they went to Harvard University or University of Maryland. We're talking about whether or not the individual is in school. Political affiliation, fairly straightforward. Personal appearance, that's something different. That's not covered under federal law, okay? You can't discriminate against someone based on personal appearance. Why is that? Because in DC, we believe that every employee, every individual should be treated based on their individual merits, work performance, their work experience, and not their personal appearance. This includes hair. You might have heard of the Crown Act that Congress legislated last year. This is already covered under the DC Human Rights Act under personal appearance. Credit, fairly straightforward, but a little bit newer. You can't discriminate against someone because of their credit history and or if you rely on their credit information and any employment decisions you make, you could be in trouble in DC with the DC Human Rights Act. I already talked about DVSOS, familial status, family responsibilities. You can't talk about, you can't discriminate against someone as a result of their family responsibilities. In other words, you can't treat employee A differently from employee B who has children versus employee A who does not have children. That's an example. Any questions before I move on? Okay, moving on to the next slide. Okay, so again, as I mentioned, I'm going to talk a little bit about religion and disability in the workplace as it relates to particularly vaccination requirements. I figured that would be somewhat relevant for the audience today. So the general provision is that employers may mandate vaccination under both federal and DC laws. But, it's a big but, we have to be aware of the reasonable accommodation requirements under Title VII, the ADA, and DCHRA. Anyone tell me why and how that's related? Ms. Harris, if I could pick on you for a moment just because you are on camera for a second. I want to go ahead and cold call you for a second if you would be so willing to respond.
Natalie, you there?
You might have.
Hello. Yes.
What do you think is the relationship between Title VII, ADA, and DCHRA as it relates to the vaccination requirements? Any thoughts on that?
Reasonable accommodation for those who are vaccinated versus unvaccinated, or maybe they have some type of accommodation not to, like religious accommodation or something like that, where they aren't getting the vaccination.
Bingo. Thank you, Ms. Harris. That was an excellent response. Correct. These laws have to do with reasonable accommodation requirements for religious and medical disability reasons, right? So if you're an employer and you want to require that all of your employees be vaccinated, that's okay. But you also have to realize that some of your employees may require reasonable accommodation, such as based on religion, as Ms. Harris mentioned, and medical disability. Okay, so how does that come about? That's why I'm sharing this. This comes about because of the anti-discrimination laws under Title VII, which is federal, the Americans with Disabilities Act, which is also federal, and then our local DC Human Rights Act, which covers both religious and disability non-discrimination. Okay, so non-discrimination includes the employer's obligation to provide reasonable accommodation in those two areas. Any questions so far? Okay, so I'm gonna do you a favor. If you have these issues, unfortunately, I can't spend a huge amount of time on it talking about it today, but there is a great resource at the EEOC's website. I've included this link here for you, and we'll get a copy of these slides to Ryan so that he can circulate it with the audience later on. But it's a long set of guidance on anything you ever wanted to know about the pandemic and EEO laws. But Section K particularly deals with vaccination. And since this is the sort of the hottest and latest issue that employers are facing with, I wanted to put this link in here for you. There's a great Q&A about what you can and can't do, what you should consider about, what sort of medical information you can inquire about a person if they say, look, I need an accommodation, which means I need to get sort of an exception treatment from your requirement to vaccinate because of my medical condition. There, how far can you go in asking those questions, right? You can consult with the EEOC's guidance document here. It is excellent. I cannot emphasize that enough. All right, any questions so far?
I had a quick question.
Yes, ma'am.
Sorry. And back to my bullet with the reasonable accommodation. When it comes to religious accommodation, is there certain type of paperwork or something that has to be given to the employer to, I guess, substantiate that particular claim, if that's the best way to put it?
Yeah, so, if you were DC government, I'd have a different response, but since you're a private employer, you can establish any sort of policy and procedure that works for you, but you should implement that policy or procedure consistently. So what I mean by that is that you can absolutely ask your employees to say, hey, fill out this form if you would like to get religious accommodation, right? You can ask them, what is the reason for why you believe you should be exempted from this requirement to vaccinate? Now, any additional issues that arise, you'll want to talk to Ryan or some other attorneys in this area because it can become very, very consequential in the conversations that you have with the employee. But at the Office of Human Rights and under the DC Human Rights Act, we do say that it is de minimis cost, right? So there is this idea of undue burden that employers deal with in thinking about and considering reasonable accommodation. Is the request that the employee making going to be an undue burden on the employer? That is the typical consideration given in the reasonable accommodation when it comes to disability laws. With religious accommodation, it's a little bit different. It's a lower burden for the employee. So unless it's a de minimis, right? So if it's not going to cost you that much, then you have to provide the reasonable accommodation. In terms of your question about whether you can ask for certification, you can. But if there is no documentation for their closely held beliefs, or if this is something that they believe in that's maybe not as conventional or well known, it doesn't mean that they're not qualified. So that's why I mean, once you go beyond the question of why do you need this particular reasonable accommodation, you may want to consult with an attorney or an expert HR professional before proceeding. I hope that answered your question.
It does. Thank you very much.
Okay. Great.
Director Kine, do you mind if I give an example or
Of course, please do.
So I think here and having to look forward to what to experience for employers is that when someone exercises this closely held belief or religious exception to taking the vaccine and providing that reasonable accommodation, I think what we have to really try to digest is allowing people to work in the workplace and provide them with, testing, emergency testing, and having, quick response testing before entering any workspace and having them isolate when getting those results. And that way the protocol becomes allowing them in to the workspace, but having them test, ensure that they are healthy and not carrying the virus to spread to your other vaccinated or potentially vaccinated employees, meaning that would they infect your other employees in the workspace. So you have a diligence or requirement necessary for you to test those unvaccinated employees, because there is a known element that you could infect other people, even though they are vaccinated. So that could open you up to some other sort of litigation if you aren't doing it. And that reasonable accommodation has to be appreciated from a cost perspective. And you can find creative ways as the employer to exercise use of making this accommodation, meaning what's the cost to you as the employer for having to test, having to provide a safe space in your office for them to, remote test for those moments walking into the office. So that's taking up space, and it's a cost to you providing the test and ensuring that they are still abiding by the other rules or preventative measures such as enclosures and 6 feet and gloves and masks. So there's also the concept that you can't take any measures or reactionary steps against such an employee because it could be construed as retaliation. And I think these are the issues that are popping up, that because they have a closely held belief or a religious exception to being vaccinated, that it's now creating a cost for the employer in an environment where costs are mounting up quickly and being prohibitive to the revenue and the bottom line of the company. So any action, you might think twice about it, because on the front end, you might be winning, but you'll lose on the back end with litigation and other things of that nature, and any other action taken by maybe the Office of Human Rights. Is that something that you would do, Director? Take action on behalf of the government for an employer behaving in such a way where it's known that there's been retaliation?
Yeah, Ryan, so if employees file a complaint with our office, that is certainly something OHR would process and adjudicate. But I want to add to, thank you for your example and comment there, very helpful. And I just want to add a tiny bit there that, this is a very, as I mentioned before, consequential area for employers, because you have different interests to balance, right? You have costs, you have employee concern of the person requesting reasonable accommodation, but you also have concerns of the overall health and safety of all of your employees, not just one. But you also want to remain consistent in your position and your application of these procedures, as Ryan was talking about. If you're going to have a test out policy, you want to apply that consistently. Otherwise, you will come under some kind of discrimination claim or retaliation claim under the Human Rights Act. For example, as Ryan was talking about, you could have a religious exception or religious accommodation request. Make sure you treat those cases consistently as you would the disability reasonable accommodation test out, right? You don't want to apply the test out policy, for instance, to a person requesting accommodation based on religion versus a person requesting accommodation based on their disability, for example. So that's very, very important. And I'm glad that Ryan and his team and the Chamber of Commerce and EAP are here for employers. That's a good service for employers to take advantage of to make sure that you are consulting with the professionals and people who work on this on a day-to-day basis so that you know that you're taking these cautious steps for your employees, excuse me. Any other question? Thank you for that question. Nope. Okay, I'm going to keep going, but if you think of any more, don't hesitate to chime in. It's not too late. We're a small group today, so I think there's time to entertain questions if any pops up in your mind as we talk about other topics. As Ryan mentioned, this is going to be a discourse, so things will come to your mind as we talk about other topics as well. Okay, let's see if my computer will let me get to the next slide. Okay, here we go. So with the DC Human Rights Act, I want to give you a little update in that it was recently amended last year by the council, and the amendment took effect this October, our new fiscal year in the government. So as of October 1st, 2021, there has been an expansion of the definition of place of public accommodation. Why am I telling you this? And I said we were going to talk about employment law today, because I assume that most of you are businesses that provide services or goods, and that's what a place of public accommodation is, okay? So what was the major change from this amendment? All right, so this was expanded in a nutshell to include person or place that anybody that provides services or goods in Washington to customers in Washington, D.C., whether or not the person or place maintains a physical location in the district. So what does that mean?
If they give services to anybody in the district, regardless of where the company is based.
That's right. So you no longer have to have a brick and mortar location. Okay, this is the way that OHR interpreted the place of public accommodation of the Human Rights Act, but it is now explicit in the law. The council amended the law to make it explicit that place of public accommodation includes places where they may not have a brick and mortar location in DC. So it could be an online vendor, right? An online business could be subjected to the Human Rights Act and its non-discrimination provisions. I hope that makes sense. Any questions about that? Okay. All right. COVID-19 changes with DC FMLA. I'm going to assume most of you as a business have a fairly good understanding of what DC FMLA is, but that stands for DC Family and Medical Leave Act, where employers are required to provide a certain number of leave for family leave and medical leave. And I just want to draw a slight distinction here. Does anyone know what the federal FMLA provides? How much time? How many weeks?
16 weeks.
Oh, Angela, you're perfect. That was a great answer. Federal is 12, but DC is 16. So you got
federal is 12, DC is 16.
Okay.
I thought
so
it was the same.
Huge distinction to remember in our minds. But I want to tell you more about the COVID-19 changes this year, or it's been in effect since March 11, 2020, actually. So it is set to expire November 5th, but I have the impression it'll get extended. All right, so what is this change I'm talking about? So in addition to family and medical leave, under DC FMLA, now there is something called COVID leave, different from family and medical. I see, Natalie, you look like you have a question. Do you want to chime in? No? Okay. You might be talking to someone else. All right. And so what does this do? This says an employee who has worked for 30 days, just 30 days, okay, or an employer of any size. So unlike family and medical leave requirements for COVID leave to apply, you only have to have been working for 30 days, and it could be an employee of any size. So that means you could have an employee of 1 or employee of 500, doesn't matter. You would be covered under this COVID leave under DC FMLA. So that employee may use up to also 16 weeks of COVID-19 leave for one of the following reasons. Okay, one is to care for themselves. when there has been a recommendation from a healthcare provider to quarantine or isolate. B, care for family or household member. So if you have to take care of a family member or a member of your household pursuant to a government or healthcare provider's order to quarantine or isolate, then that employee can ask to take COVID-19 leave. Childcare closure. If an employee has a need to care for a child whose childcare facility, that includes schools, is closed, then the employee can ask for COVID-19 leave to supervise their children. So one big note here, employees tend to get this mixed up by believing that the leave provided under under DCFMLA is paid. It is not paid leave. The law does not require payment under DCFMLA for federal medical, family, medical, or COVID-19 leave, right? This is unpaid leave. It's just the employer has to allow the employee to take time off. But, and this is a really big but of course, employees can get paid for these types of leave through a number of different ways, right? They can get paid through their own annual leave, their sick leave, any kind of PTO they might have, depending on what sort of policy you have in place. They can also now get paid through UPL, Universal Paid Leave, if they're qualified for that. So if you also have leave donation policy in your workplace where the individual themselves, because they've only worked for 30 days, may not have leave accrued, but maybe their colleague who's been working there for 10 years might have a lot of accrued leave. They can donate that leave if you have that kind of policy in place, a leave donation system. So they can get paid through a number of different ways. There's also something called the FFCRA, Families First Coronavirus Response Act, you might have heard of early in the pandemic that Congress legislated, that also requirement payment for certain types of COVID leave under those laws. I'm not going to talk about that because I'm not an expert in that area since we don't enforce federal coronavirus laws, but you want to think about the fact that there is this COVID-19 leave and that you may have to pay the employee through the other types of laws that require payment. But DCFMLA itself does not require an employer to pay an employee for the leave. I hope that makes sense. There's always a little bit of confusion around this, so I wanted to make sure to be clear. Any questions?
Yes, I am Maria Fernanda Borja from the Latino Student Fund. I have a question regarding the paid leave. So they can submit a paid leave claim form, so they get the payment for the COVID-19 leave, the employees. Like, for example, like when they request, I'm sorry?
You're breaking up a little bit. I'm not catching all parts of your questions. I'm only getting bits and pieces. I don't know if it's just me.
I'm sorry, the internet is not working well.
Do you want to put it in the chat so we can see the full?
Yes, that will be better.
Okay, sorry, it was breaking up. We'll look forward to your question in the chat.
While she types the question, I believe that the question was related about the funding to pay for the leave that the person is taking. Oh, here's the question.
Yeah, I see. So Maria says DCFMLA pays for 12 weeks of family leave. It will be the same for the COVID-19 leave. So DCFMLA does not pay for 12 weeks of family leave. So DCFMLA says you get 16 weeks of family leave. DCFMLA, that particular law itself doesn't require employers to pay employees. But what I was saying is that there are other provisions, other policies and procedures in place that might allow a person to get paid leave, and they can sort of use that, think of it as a source of payment to pay themselves while they're on family leave, for instance. And the same thing with COVID-19 leave. Part of it is that FFCRA, the federal law, and there may be other local laws that require an employee to get paid for the first part of the leave. But the COVID-19 leave under DCFMLA itself does not require payment for the leave, the 16 weeks. But it does require an employer to grant an employee up to 16 weeks of leave for the reasons we talked about, to care for themselves, to care for a family member or a household member, or to care for their child because their child care is not available due to COVID reasons. Did that answer your question a bit, Maria? I know this is confusing.
Yes, it does. And they can also, can they take both if they already, if the employee already took the 16 days of family leave, then in the same year, can they take the 16 weeks of COVID leave?
So some of this is an excellent question, Maria. Some of this can overlap depending on the reason for the leave, right? If the employee is sick and they need to take leave, medical leave, so it might qualify as both medical leave and COVID leave, depending on the eligibility requirements. So it can overlap, and if it does, it would be counted. So there is an excellent guidance that OHR has put out around all of these FAQs around how to apply this COVID-19 leave on our website. And I'm going to include that here for you as well. And I'll drop the internet address here in the chat for you in a minute. So the answer, Maria, there is just to wrap it up. It depends, but it can overlap.
Oh, okay. Thank you so much.
I hope that answered your questions. If it didn't and you have follow-up questions, don't hesitate to reach out to me, and I'm happy to connect with you offline as well. All right. Any other questions? So there's a little icon of our guidance document, but I will put it in the chat. Or if Larry or Rosa can find it on our website and put it in the chat, that would be helpful as well. Okay, so moving away, but to something related, Universal Paid Leave Act. I'm gonna give you a little refresher in case you're not familiar with this one. What does this law do? Anyone familiar with the Paid Leave Act, Universal Paid Leave Act? Not really? Okay. Well, good. Then I'm glad I'm talking about it because as I suspected, this might not be as well known. So as I mentioned at the top of this, this seminar, what this law does is that it allows private sector employees, so that doesn't include this district government and federal government, but private sector employees that you all may have, to receive pay when taking the following types of leave: up to 8 weeks of leave to bond with the child, whether that's an adoption or a foster children or giving birth, 6 weeks to care for a sick family member with a serious health condition, 2 weeks of personal medical care. So this is what I mean. Under the DCFMLA and federal FMLA for that matter, it does not require payment. That particular law never said employers have to pay employees. You just have to allow people to take off for the amount of time designated by each of the provisions. But now what UPLA is saying is that if you're a private employer in the district, you have to allow employees to take leave, and then they also have to get paid. The only difference with this one is that the payment is made by DC government because employers are contributing to this fund, where the Department of Employment Services, DOES, will be the one issuing the payments to the employees. But the employer will have to certify to the DOES that the employee has taken the qualifying leave, like this bonding with the child, caring for a sick family member, or for personal medical care. Does that make sense? I know, again, it's a little bit quirky, a little bit confusing. There's a lot of things going on. And, I could do a whole session on leave laws, which is could take a few hours. Any questions? Ryan, do you have any questions? You look like you might have questions.
So I do recognize the Universal Paid Leave Act, and I know it's new, and I know it came, employers weren't very happy about it because it seems like an expensive new requirement, but it is a part of the new landscape. And I think, from an economic perspective, you now have to treat your expenses differently, manage your budgets differently, knowing that this is a possibility that you would have to pay an employee for, the reasons enumerated here under the act for the type of leave. So what does the employer need to do to ensure that they can stay afloat and weigh these costs going forward? That's just one of the things an employer will have to be creative about and plan, especially when from the beginning phase of onboarding to the end of that employee's time with the business. So you always have to have reserves to ensure that you'll be able to survive, and that requires you to be creative. And I think it's just a new challenge that you have to adapt to and be creative to resolve. And talk with your cohorts, go to your business next door, talk to the folks in networking environments such as the DC Chamber to see what people are doing to prepare for any such issue. And obviously, given the novel coronavirus now we're living with, we've got to be wise in how we prepare for this cost up to 8 weeks.
Great. Thank you for that comment, Ryan. I'm really grateful that you're here to provide this sort of advice and counsel, because I certainly can't provide any sort of legal advice or any kind of advice, really. We're just here to provide information and educational training. So I am so appreciative of your presence in making these useful comments for our audience. Thank you.
Thank you.
So the other bit about the UPLA is that it, like any other law, prohibits retaliation and what we call interference. So that might be what's more applicable for you in the audience as employers, is that although the DC government is dealing with paying out employees based on these types of leaves, you cannot retaliate against or interfere with their right to obtain this payment from the DC government. So if there are claims of retaliation or interference, those claims will come to the Office of Human Rights, and that's where we would adjudicate these claims. So there are two types of claims. I got ahead of myself a little bit. So for payment and claim determination, so if an employee wants to say, I didn't get 8 weeks, I only got 6 weeks, or my employer said I didn't take leave for childbirth, which actually it was for childbirth, things like that. Disputes around payment and claim eligibility and claim determination, that would all go to DOES or the Office of Administrative Hearings, which Ryan mentioned earlier at the top of this training seminar. Those would be the two places that those claims would go to. But for retaliation and interference claims, those will come to OHR. So there are 3 separate places a case might go to. So again, it is probably a good idea to connect with Ryan or someone from his team to figure out where these claims are if you are dealing with Universal Paid Leave Act, because they are in 3 different places depending on the type of claim. All right. So for OHR, again, what we adjudicate is if an employee says you as the employer retaliated against them for using UPLA, or you interfered with their claim by not timely certifying their leave to DOES so that they can get paid, things like that, that may come to OHR, and we would be investigating and contacting you to resolve the investigation, which we'll talk about in a little bit here, the process at OHR and what that entails. All right, so what's new with this UPLA? I can tell you we have some information on our website. So I've included our website information, our pin site to this particular information about universal paid leave. But OHR has also adopted emergency rules in implementing this law, so that if you want to read up on how exactly we're going to be implementing this law and how exactly we're going to be looking at, what is retaliation, what is interference, what kind of claims come to OHR, then you can look at that emergency rule that we have adopted and for which we're posting a notice to adopt as permanent rules. Okay. So I wanted to make sure you all were aware of that. Any questions?
I don't think so. Thank you so
All
much.
right.
Yep.
Thank you. And because we're coming up on the hour of our seminar, I'm going to speed this up just a little bit to get through and then take questions that folks may have. And well, this is a good segue to hand this off to my colleague, Larry, who we adoringly call Larry VP because his last name is Villegas Perez. And so let me tell you just a little bit about him. He is an excellent addition to the Office of Human Rights. He's currently our program manager. He brings with him over 20 years of experience in advocacy, executive coaching and leadership, and mental health. And he's been an excellent ad. He's got experience in federal government and local government, and he's been a longtime resident of the district. And he is a very proud descendant of Native American, Hispanic, and Middle Eastern heritage. So welcome, Larry, and take it away.
Thank you very much. And actually, I was going to ask you, since all my bullets are going to appear, let's see, should I manage my own slides? Let's see how this works. Okay, so thanks again, Nin, for the kind introduction. And I want to also thank the DC Chamber of Commerce and Angela Franco, the president, and Ryan as well for the time and commitment, not only to do the work you do, but also to bring also updates on what is happening from the Office of Human Rights to make DC a better place to live and work for our residents and everybody else who has business in Washington, D.C. So under the Tip Wage Workers Fairness Amendment Act, which is a very long name, as you may have noticed, we're going to call it from now on TOF, because it has a TWF. So I was trying to think like, how are we going to call this program? So from now on is the TOF program at the Office of Human Rights. And it's tough as an adjective because he wants to strengthen everybody who participates, employees, but also employers, so they can actually be in abide by the law, so everybody gets what they need to get. Employees receive their wages, employers receive their profit and expansion of their businesses, and of course, the district also gets their taxes, so everybody's happy. Very good. So what is the role of the Office of Human Rights under this law? So it has several roles, but the biggest one we're going to do next, but I cannot do it myself for some reason. Thank you. Magically appeared. So the mandate reads that the Office of Human Rights needs to create sexual harassment training and also certify outside vendors to provide that anti-sexual harassment training to employees and employers. And regarding the employers, have to be those who at least have one or more tip wage workers. And I left, we have the DC code section there for those who are more curious about the law, so now you can find it. We are also mandated to collect sexual harassment policies and complaints from employers, which would include how to make claims to the Office of Human Rights. So I am an employer. I have people who receive tips as wages, and I have several things to do. First, I have to have a sexual harassment policy. I have to let my people know what to do and how to make a claim or how to contact the Office of Human Rights. But before I continue, I want to see in the chat or the hands or so, how many of you have ever worked at a bar, at a restaurant, or when you went to school, or right now you may have a second job? Okay, see? One thing I didn't know about you, Nin, now, okay, Natalie, thank you very much. So, Osman, thank you. Okay, so we are in the presence of a pretty educated group about receiving tips and the things that people sometimes have to do to keep those tips, like being nice, laughing all the time, etc. And that creates a gray area sometimes for being either mistreated or disrespected, even though what we want to do is to create a nice environment for everybody. So we know already that we collect sexual harassment policies and complaints from businesses, and there are other roles about to come up. Nin, when you're ready. Excellent. So one of the most important aspects we think that is coming up is we need to raise awareness regarding employees' rights and benefits, as well as employers' obligations. We have done several consultations with the community, and the one aspect that always comes up is, I had to do this because otherwise I would lose my tips, or my employer did not inform me about all my wages, or I asked for permission and then they punish me, getting me off the schedule. So awareness, awareness, awareness. You have rights and benefits. We are in Washington, D.C., and Director Kane already told us that we have more protections than the federal government. So this is a great place to live. It's a great place to work. And that's what we're trying to have everybody understand. Now, we also enforce laws through investigation, mediation, and prosecution, which Director Kane is going to give us more information about that. And I'm ready to move to the next. Excellent. So to create and certify sexual harassment prevention training. So create and certify, that's the most important part here. So we have taken steps to create and certify outside vendors to provide anti-sexual harassment training to employers who employ one or more tip wage workers. What does that mean? So we're bringing together, thank you very much, people in at least, listen to this, English, Spanish, Vietnamese, Chinese, Korean, French, Hindu, and Arabic. And I'm sure that I already said English and Spanish, because what we want to do is we want to certify people who can actually provide the training in their own language. So we overcome more or whatever barriers people may have. So we are doing the consultation with groups that represent victims, workers, and employers regarding the content of the training. And the training has to include specific portions, but I know that it's going to grow a little more. For example, how to respond to sexual harassment, how to intervene if you just see it, if you are a witness, and how to prevent sexual harassment by coworkers, management, and customers. So this is going to be, or this is already, a huge endeavor for Washington, D.C. We're talking about more than 2,000 employers and more than 20,000 employees. The important part about this is that employees, managers, owners, and operators must attend the training every 2 years. And managers have to do it in presence. Now, because of COVID, we're planning to do everything at the beginning via video calls or virtual, etc. But eventually, it's going to be classroom-like. So to create and certify sexual harassment prevention training. So what we also need to do is make sure that people who participate in our working group know the history, know the law, etc., so they can go and implement it. And I think I'm ready to move to the next one. Okay, so OHR also needs to collect and track. Employers have to submit to OHR a certification for each employee that they completed the anti-sexual harassment training within 30 days of the training taking place. That also means people who are employees, people who are managers, people who are owners or operators. They also have to submit a copy of their sexual harassment policy. Let me ask you this now. How many of you have recently taken a look at the sexual harassment policy in your workplace? You can show me the hands, you can put it in the chat. Right, that's exactly what I thought. We look at it, we sign it, and then we never see it again because it's not something that we pay attention to all the time. But let me just make this very quick caveat here. When I graduated in one of my psychology degrees, my work was to investigate what meant as sexual harassment among women, depending on their hierarchy at work. So what I found after interviewing almost 50 women who were managers, who were in management, who were in like lower management positions and entry level, was that some of them may have identified sexual harassment when it was not sexual harassment, and those were cases that already went through court, but they said, yes, it is, and then send it to HR for them to investigate, because their purpose was not to determine what was sexual harassment, but to actually receive the claim and send it to the person who was going to investigate it. In this case, the HR person. So that's why it is so important that everybody goes through the training and we receive the training certificate or the certification that they completed it. Also, they have to report complaints of sexual harassment. Now, this policy has to not only say what it is, how to prevent it, or what procedure to follow, but also they have to give us a copy, and we will keep those records for 5 years, at least. We don't know what's coming next, but it's going to happen. And we are creating a platform that is going to be very easy for employers to submit their paperwork. And we are using some of those employers who are actually part of our working group to actually test everything we do. We do the platform, we send it to them, they test it, they give us feedback, we give feedback to the person who is helping us, and then we keep it going. It is also important to know that we are bringing not only the people who are mandated by law, but also those who have an interest in that, that this program succeed, because we want to have as many perspectives as possible. So we have people who work in policy, we have people who work in unions, we have people who work with employees, we have bartenders, we have waiters, etc. But I'm still looking for more people who speak other languages, like the languages that I already said, not only because it's the law to comply, but also because it's the right thing to do. And that's exactly what we want. I'm ready for the next one, because I feel fired up. So I say, got tips, got rights. That is exactly what we want to do. And if you, as you see that all those, you have the right to be free from discrimination in the workplace, to be free from workplace harassment, including sexual harassment, to be free from the to qualify for unpaid family and medical leave, like Nin already explained, to request time off to attend a child's school-related activities, to accrue and use paid sick leave, unsafe leave, if you're eligible, of course, to be accommodated in the workplace during pregnancy, to remain free from employer retaliation, like Ryan said, for discussing or exercising any of these rights. And of course, to file a complaint for violation of workplace human rights with the Office of Human Rights and violation on wages to the Department of Employment Services. I have taken upon myself, because it's part of the program, to do outreach. So I go to a restaurant, I'm always asking, how is it going to the person who brings me the water or the bread or the nachos or whatever. And then I also ask the waiter or waitress, how is it going? Do you know about this? Do you know about that? Because now it is like on my forehead, you got tips, you got rights. So it is important to mention that the law specifically says that this language has to be presented in conspicuous places at work so everybody can see it and identify, maybe I have an issue here. Because many times when, for example, Osman said it, Nin said it, and somebody else said it, when you were working for tips, did you know all the rights that you were entitled to or benefits? I'm just asking anybody in the room, virtual room, of course. Like Nin, did you know everything that you were entitled to, so to speak? Right? Osman, how about you? He's being shy. It's okay. Okay, so the important thing is everything that Nin already said about, Human Rights Act and FMLA, etc., is here too in an easier and more succinct way for people like you and I, regular individuals on the streets or at work, can see it, can identify, and can say, maybe I have an issue to address. Nin, you were about to say something.
No, I was just thinking that, if folks are feeling slightly or partially confused or going, hey, I didn't know if this was the case. What is that? It's completely normal. That means you're learning. That means that, there's more for you to learn about. It is a very vast area of the law, and we do have a broad set of rights, workplace laws and rights in the district. So it's completely normal. If you have questions, feel free to reach out to me, to Larry, and I'm going to give you one more contact name at the end.
Absolutely.
But Larry, please continue.
Yeah, I am ready for the next one. Oh, can we go back just for me to close? Okay, so
Sure.
You are going to see a change in the city. This is what we are trying to do through the Office of Human Rights. We are going to educate employees, we are going to work with employers, and we are going to work with everybody to make sure that DC, as I said before, is a great place not only to live, but also to work. So we go back to being as vibrant as we were before COVID. Now, if you have an idea, a thought, or somebody who speaks another language that you know that they have experience in training or harassment or so, please give me their information. We're going to put our information is going to be available not only in the chat, but also through this presentation. And let's make this a movement in DC so people are aware of their rights and benefits, and we all live in a better place. And with that, I'm ready for you to take it away, Nin.
All right. Thank you, Larry.
Thank you.
So we're going to get back to talking about complaint processing at OHR now that we've covered most of the laws that might be of interest to you. Like I said, this is just the abridged Cliff's Note version of what we do and what we cover. Again, I encourage you to take advantage of our HRL Human Rights Liaison trainings if you want to learn more about our laws and more details about each of the provisions. But we'll proceed now to the process so you can understand what we do and what the process is if you happen to be in front of the Office of Human Rights. Okay, so in order for there to be a complaint at the Office of Human Rights, the alleged incident must have happened in DC. We're a local entity, so we don't have federal coverage, just DC. It has to be based on one or more of the 21 protected traits we talked about at the beginning of this seminar under the Human Rights Act, or another law that we enforced. I mentioned all the long list of laws that we enforce. And it happened within the last year for the most part. Most of the laws have a 1 year, what we call the statute of limitation for the complainant to file with our office. Okay. So what does the life of a case look like in DC at the Office of Human Rights? The case starts with what we call a questionnaire that's filled out by the employee in your case. Then OHR will conduct what's called an intake, where we review the questionnaire, see if it states a claim. We will interview the complainant. At this point, employers are not involved yet. If it states a claim and we docket the charge for investigation, then we will serve what we call this formal charge of discrimination onto the employer. And then you will have an opportunity to engage in mandatory mediation, where we'll try to resolve the case without a formal investigation. But if that doesn't work, the case will proceed to a full investigation. And once the investigation is completed, we will issue a decision on whether or not there's probable cause to believe discrimination occurred, or a violation of another law occurred. And if we find probable cause, as I mentioned earlier, we will try to conciliate. In other words, again, try to resolve the case without further action. But if that doesn't happen, or if it's not successful, then we will have the case certified for a public hearing before the Commission on Human Rights, for the most part. Some laws have a varying procedure, but for the most part, it will go to a public hearing before the Commissions on Human Rights. All right, so quickly about what we call choice of forum. Complainant has the option to file with OHR or to file their complaint in court. For those of you that might be familiar with EEOC complaints and Title VII, it's a little bit different, because with federal laws, in terms of Title VII, for instance, employees have to first file with EEOC before they can go to court, right? And then they get the right to sue, and then they can go to court. Not so in DC. The employee from the beginning has a choice. They can come to OHR or they can go to court. But once they come to OHR, they are at OHR unless they withdraw their complaint prior to OHR's determination of what we call our letter of determination, which you'll hear me refer to as LOD. And once OHR issues this LOD, the determination, a complainant cannot withdraw or file a new suit. Or they can withdraw if they want to, we'll dismiss it, but they cannot then move to go to court. They can only petition our decision at DC Superior Court for a review of our decision. I'm gonna pause here for a slight second before I go more into detail of each of those investigation steps. Any questions? Is there something in the chat? Nope.
I don't see anything.
Okay. Any questions? All right, seeing none, I will move on. All right, so like I mentioned before, the first step was for the employee in your case to file an intake questionnaire with our office. And then we would look to see if it states a claim. If we docket the charge, we would service and then mediate. So we will send what's called an LON, letter of notification, to the employer. That's you, right? We will send a letter to you to let you know there's been a charge of discrimination filed and that you will have to attend a mandatory mediation. And in that LON, there will be a date for that mandatory mediation. Now, practical tip for you, you might want to reschedule that because you may have a conflict. That's fine. Contact our office. We will reschedule the mediation. It will also provide some of our case deadlines for investigation so that it can proceed as soon as possible. All right, those things may be things like asking you, the employer, to submit what's called a position statement responding to the charge of discrimination. I'll get to that in a moment. All right, so once we serve that charge of discrimination on you and there's been mediation, and let's say the mediation is not successful, we will proceed with the full investigation. What does that mean? What do we do during our investigation? Are folks familiar with our process? You know what happens when we investigate? Anyone? Anything in the chat? Not yet. We might have come to part of our program where people might be getting hungry and less able to participate. So we'll move forward, but throw in your responses in the chats or chime in if you've got a response. Don't be shy. All right. So part of our investigation process includes an investigator asking, as I mentioned before, the respondent, which is you, the employer, to submit a position statement within 45 calendar days. And so that position statement is in a nutshell and sort of an answer or your response to the charges that are alleged in the charge of discrimination. So the charge might say something like, the employee alleges that the employer discriminated against the employee based on, let's say, race, sex, and disability. So then the employer could put their position in their position statement and provide a response to those allegations. Once we've gotten that, the investigator might contact the complainant for a rebuttal to, again, respond to what the employer might have said in response to those charges. Then the investigator could also ask for additional information to both parties, complainant and respondent, for what we call an RFI, request for information, where we would ask the parties to answer some questions or to provide some documentation.
Director Kane?
Yes.
What is your position or what are your thoughts on if there's a simultaneous filing with the EEOC? How do you guys treat the timing of moving complaint forward through your office, knowing another EEOC complaint is out there?
All right, that's an excellent question, but a loaded one. So I'll try to break it down a little bit. So first, because of the work share agreement, we have what's called dual filing system, which means if you file with one office, assuming that the claims are covered under both entities, it would be like as if you filed with both EEOC and OHR. I'll give you an example. If you file, let's say, a race discrimination charge with EEOC, it will count as if you have also filed a race discrimination charge with OHR under the Human Rights Act, okay? So your question, Ryan, was what happens if a complainant has filed in both places? Is that your question?
Yes.
Okay, so for OHR, what we would do is, if that's something we look into once we get a claim through our intake questionnaire, is to ask the complainant whether they have filed a claim with any other administrative forum, including the EEOC. And so if we find information to establish that the employee has filed with the EEOC, we will dismiss the case if the charge is pending with the EEOC. Sometimes the EEOC will have deferred jurisdiction to OHR, meaning they will have said, okay, it's counted as filing with EEOC, but we want to defer to OHR to conduct the investigation. So it will be a dual filed charge that OHR will investigate on behalf of the EEOC and the DC Office of Human Rights. Did that answer your question, Ryan?
It does, yes. Thank you so much. And I hope
Okay.
that helps employers listening as well.
No, that's a great question, because you're right that sometimes employers might be confused because you might get a copy of a charge from the EEOC and a copy of the charge from the OHR. If that happens, feel free to call our office. We'll be happy to work with you on it. Let us know if for some reason we didn't know that it was filed with the EEOC, but you know that because you've already gotten a copy of the charge from the EEOC. Let us know. Contact our office and say, hey, there's already been a charge pending with the EEOC that I've already provided responses to and documents to. We don't want to duplicate efforts. We don't want to overburden our employers because we know you have important things to do on a daily basis, and we don't want to burden you. So if that happens, certainly let us know so that we can dismiss it if proper. If EEOC has already assumed jurisdiction, is already taking action to investigate the matter. Okay, great question. Thank you.
Of course.
So During the investigation, OHR may also conduct witness interviews. So we will ask complainant if they have any witnesses that might have relevant information about their allegations. We can also ask employees the same question. Do you have witnesses that would have relevant information to the allegations that are being raised? Okay. And then we will interview those relevant witnesses. All right, I want to caution folks here, and you know, sometimes things are out of compliance or not complied with because people are not aware of the rules or the regulations. So I want to caution here that if an employer fails to provide timely responses or they resist the OHR process, there can be consequences. But that rule applies to both parties. It's not just for respondent employers. It also applies to complainants. If the complainant is not cooperating with OHR, we can dismiss the case. If an employer is being resistant to our process, not providing information in a timely basis, then we might docket a new charge of discrimination for resistance. We can also assess fines, and there's even something so far as to say the imprisonment under the DC Human Rights Act. I'm glad to say we've never had to enforce that bit because it hasn't come to that. I'll just say that, but I want folks to be aware of these consequences. Okay, so what happens after we complete the investigation? We will issue this LOD, letter of determination, and that will explain what we've done in the investigation, what information we got, and how we reached the conclusion that we did in terms of making a probable cause determination. This letter will be drafted by the investigator. It will be reviewed by an attorney, and then it will be finalized and issued to the parties. Now, the LOD, if you ever get these letters, you as employers should read them carefully. You have your lawyers or HR experts look at them because there will be information about next steps depending on the result of the determination. So what are those next steps? What happens after OHR's issuance of the LOD? First, if there's a probable cause finding, all right, you, the employer, can file what's called a request to reconsider. You can say, hey, OHR, you sort of missed this other fact that might be important in this consideration, right? So you could file a request to reconsider. If that's denied, the case will go to conciliation to try to resolve the case before we proceed to a full hearing. If that's granted, obviously we will reopen the investigation and we will reevaluate the case based on the perspective that you've mentioned in the request for reconsideration. All right, what happens if there's no probable cause finding? If there's no probable cause finding, the complainant, like the employer in the probable cause finding, the complainant, the employee, can file a request to reconsider with OHR. Again, they can also say, hey, OHR, you got this wrong when you issued the no probable cause, you missed this fact, or you misapplied this law, or I found new evidence that might make a difference in this decision. Same three bases for either party, okay? It's, you can file a request to reconsider based on misapplication of the law, right? Misstatement of the fact, or you have discovered some new evidence that wasn't available to you before during the investigation. The key is that new evidence that was not available during the investigation. It's not something that you discovered later, but it was available earlier, okay? So based on those three bases, any party can file a request to reconsider if they are unsatisfied with the probable cause or no probable cause finding, okay? The other thing with these dual filed cases, like Ryan mentioned earlier, if it's a dual file case, you'll know, by the way, the charge will have an EEOC number as well as an OHR docket number, okay? If it has the EEOC number, it means it's dual filed. The complainant can request for what's called a substantial rate review from the EEOC to see if the EEOC has any differing thoughts or opinions based on the decision OHR has made. Okay. The other thing the complainant can do, they can skip the request for reconsideration step altogether, and they can just go ahead and go to court, go to Superior Court, and ask for what's called a petition for review of OHR's decision. All right. If the complainant does that, obviously you will be notified and you will be made aware of this petition for review, and you can participate in that process. Any questions? I'm going to pause here. That was a lot of information.
Anything
The
in
chat is
the chat?
clear.
Did I hear a question?
No, I just said that the chat was clear.
Oh, yeah. Mhm.
Okay, great. Then let's see what happens after that determination and the LOD. So as I mentioned earlier, if conciliation fails after that post probable cause finding, the case is certified for a full hearing before the Commission on Human Rights. I will say that is like a trial. Okay, there will be discovery. There will be a scheduling order from the ALJ, the administrative law judge. There will be witnesses that will have to be subpoenaed and appeared for the hearing. And then the ALJ will make a recommended decision that will be finalized by the commission, a tribunal of commissioners who will review the ALJ's recommended decision. Okay. I don't care about the government cases. It takes a slightly different track for government cases, but for private sector cases, that is the process. Any questions about that? Okay, so what happens after the case is set for a hearing and the hearing takes place and there's a decision? Well, the commission, as I mentioned, the tribunal of commissioners will make that final decision. If you're not satisfied with that, what we call the agency final decision, then you can request reconsideration like you did before with the investigation process. You can also file a request for reconsideration of the final decision with the commission. Or you have a choice. You don't have to do that if you don't want. You know, if you want to waste your time, that's fine. You can go and appeal the decision to the Court of Appeals. This time, you're not going to the Superior Court. You are going to go to the Court of Appeals to appeal the final decision from the Commission on Human Rights. That's all I have for the process. I'm going to give you one more tidbit of hopefully informative information. But any questions about OHR process and procedures? Nope, nothing in the chat. Larry is telling me from his shaking of the head. All right. So this, if you found, this complaint and procedure bit not as interesting to you, I hope this next bit will be interesting. There is pending legislation before the council that you might be interested in, and it's called the Human Rights Enhancement Amendment Act of 2021. If this legislation is enacted, if it passes, what it will do is that it will add homelessness as a protected trait under the Human Rights Act. So now we will have 22 protected traits overall and 19 protected traits in employment, because this means if it goes through, if it passes, again, I can't emphasize enough, it hasn't passed, it's just been introduced. Okay, there's been a hearing, but it hasn't passed. But if it does, I want employers to be aware that you can not discriminate against someone based on their homelessness status. Okay, what does that mean? That means if a homeless person, individual without a permanent address, a permanent residence, address, applies for a job, employers can't simply turn them away because they happen to be in a homelessness status, okay, or they are without a permanent resident address. What else does it do? So again, if it passes, it will also begin to include independent contractors in the definition of the term employees. Okay, currently the DC Human Rights Act in the employment sector, only covers employers and employees in terms of the anti-discrimination provisions that we have. So now this will include the definition of independent contractors. And I am recalling perhaps a previous EAP seminar where we talked about this legislation when it was coming down the pike. So hopefully if some of you guys were there, this is a good reinforcement of this same information. Again, if it passes, independent contractors who are typically not deemed employees for purposes of anti-discrimination will now be treated as employees under the Human Rights Act. Next, very big thing. What this legislation will do is that it will define in the statute, in the codification of the law, what constitutes workplace harassment and sexual harassment. So Typically, the Office of Human Rights, along with other administrative forums and courts, what they've been doing is that they've been interpreting what harassment is and what sexual harassment is based on what we call case law, right? Based on judicial decisions that have been issued in the past. Now, we will have a set of explicit definitions that will cover what a harassment is or what sexual harassment is in DC, all right? And the other bit you probably may not be as interested in, but I'll tell you anyway, because it's part of it, is that it will require OHR to provide training for law enforcement personnel in terms of homelessness and how law enforcement and law enforcement decisions impact people, vulnerable people in that sort of community. Okay, so that, I think that's it. That brings our presentation to its conclusion. Finally, any questions about this or anything else? And I've on your screen, you'll see our various contact information. I've included Stephanie Franklin, who is the director of our communications and community engagement, in case you have questions about upcoming events, if you want to get engaged with OHR's work, if you want to attend our trainings, like the HRL training we've been mentioning here, contact her. She'll have a lot of information for you. Larry, whom you've heard from, his information is here. And if you want to contact me, I've put our OHR Ask the Director email address. This is closely monitored by our staff so that you can get a response promptly and quickly, and I'm made aware of those requests when they come in as well. Any questions?
If there aren't any questions, I'll jump in and say thank you so much for participating in our Employer Advocacy Program seminar. We have a few participants left. I do want to reiterate that Comcast Rise has provided $10,000 grants. It's going to provide $10,000 grants to 100 DC-based businesses, as Stacey Burnett mentioned at the top of the programming. I want to give an incredible thank you to both Director Kane and Program Manager Larry VP, affectionately called. We learned a lot of great things today in your programming, and the EAP seminar has been enriched by this presentation. We have this recording, which we will make available along with the presentation and slides contained therein. We will also send out a questionnaire asking you all how we did. So please don't be bashful letting us know how we've done today so that we can improve and do better the next time. And I think we've done excellently today. I think we learned a wealth of information. We got a lot of updates and kind of got a way to navigate the new landscape of work from home and then returning to the workplace, as well as any potential complaints being filed with the Office of Human Rights and the interplay with the Equal Employment Opportunity Commission at the federal level. I believe that with this type of information, we will be better going forward, and it's necessary to know what the government's involvement is at the local level and federal level as far as employers conducting business. Let's see. This is Latino History Month, and we had some good points in focusing on some of those issues that the Latin community faces in employment and from a human rights perspective. And I think it's critical to recognize that we all have an opportunity to be employed and employed in a way that we're cared for and acknowledged, no matter the basis of our race, color, place of origin, and of many other unique, the 21 in DC, the 5 federal that are protected elements or classes for people to be advocated for and protected. So this is our end. This is our conclusion. I'm so happy that you've been here. Please make use of the Employer Advocacy Program, knowing that we're here to help you confront any unemployment matters before the Office of Administrative Hearings. And we will get other information out about our next seminar.
Thank you, Ryan. Really appreciate being here. Thank you, Angela.
Of course. So this is our conclusion. Bye, everybody. Have a great rest of your week. See you next time.
Bye-bye. Thank you again.